I don't have very much time, so I'm going to try to cover a couple things, and hopefully they're important things. They're important things to me, and they're important things to you. For those of you who have been in the food industry for a while, you probably know the before Jack in the Box era and the post Jack in the Box era. I spent about 4 years of my life defending Jack in the Box in several hundred lawsuits that came from the Jack in the Box E. coli outbreak, and in doing so got a in the trenches view of what it's like when a company is under assault. After the Jack in the Box outbreak, I switched sides basically, and in the Odwalla E. coli outbreak, which involved unpasteurized apple juice, I represented several of the families of children who were seriously injured. Since then, we started Marler-Clark, which is the firm of which I'm a partner in, and we do almost exclusively foodborne illness litigation representing mostly children, because as you probably know, when it's a serious case, it's typically a young child that's involved, because adults with a more advanced immune system, et cetera, typically don't end up either dying or being in the hospital because of exposure to foodborne illness. If you would have asked me 8 years ago, or almost 8 years ago, when the Jack in the Box outbreak occurred, whether I was going to spend the majority of my legal career doing nothing but foodborne illness litigation, I would have certainly said no. But in fact, that's what I've done. And not only have I spent my entire career doing that, I've gotten busier and busier as time goes by. I don't think it's because there's more foodborne outbreaks now. I just think it's because the epidemiological investigations, the physicians treating people, the health departments just have so much more experiences, so they're finding the source of outbreaks where a lot of times the outbreak sources weren't identified. I think that's especially the case. I'm from Seattle, Washington, and because we were the epicenter of the Jack in the Box outbreak, the health departments in Seattle, Washington are extremely experienced in identifying outbreaks. They do a lot of the genetic fingerprinting of the outbreak strains of the bacteria and that sort of thing. So I don't know if we have more outbreaks, but I know that more often than not they find the source of that outbreak. What I want to talk about today is, and don't write this down because I'm going to criticize this viewpoint. This is actually a slide from another presentation that I stole from someone who will go nameless today, because I'm going to describe this as conventional wisdom. And in saying that, I mean there is some wisdom implicit in this, but this is the idea that a HACCP plan and HACCP records are evidence of good food handling practice, and that's probably the case. The problem with that view is if your food establishment is involved in a foodborne illness outbreak, that doesn't matter anymore. It just doesn't matter. And this is why. I'm going to teach you two legal concepts today. One, strict liability. I'm going low tech over here. And the other is called constructive knowledge. Now, I went to law school for 3 years, and I didn't understand this when I graduated, but you're going to understand this today, I promise. When you hear about foodborne illness litigation, often what you think of is negligence. Was the food establishment negligent? Did they not have a HACCP plan? Did they not have good hand washing techniques or procedures in place? Did they not have like a little checklist where people have to go, and when they go to the bathroom, they do a little checklist, yes, I wash my hands. All the sorts of things that you'll probably hear about today. Negligence doesn't matter in the vast majority of lawsuits that we file. And in the materials that we sent around, I included a copy of a complaint, and in there you'll see a section on strict liability. Strict liability is the notion that if you caused an outbreak, and this is what I'm talking about today is a situation in which, let's use hepatitis for example, because in fact my firm has filed 3 class action lawsuits in the last year on hepatitis outbreaks. Because typically when there is a hepatitis outbreak, the source is found, they test one of the food workers, they test positive for hepatitis, bingo bango. And why is it bingo bango? strict liability. Strict liability is the notion that if you cause an injury, you're liable for an injury. So if your food establishment causes a hepatitis outbreak, you're liable. It doesn't matter whether you're negligent. That's strict liability. Second, constructive knowledge. This is the idea that in a lawsuit, let me give you an example. You signed up for this seminar. Let's say you flew in, had a few drinks last night, thought, I'm going to skip the morning session. I don't want to hear no lawyer talking. So you slept in. You weren't here. You didn't hear what I have to say. You have constructive knowledge of what I said, even though you weren't here, because you could have known what I was going to say if you had shown up. That's constructive knowledge. Applying that to a hepatitis outbreak, let's say one of your workers goes to Mexico. You don't know about it, but you could know about it. You have constructive knowledge of the fact that your worker went to Mexico. Let's say Joe Bob, who works making salads in your restaurants, always goes to the bathroom, never washes his hands, and brags to the other co-workers, I never wash my hands. Screw that. I don't believe in germs. You have constructive knowledge about that. So when you get sued in a lawsuit, it's not just what you know or what your managers know. It's what you should know. The thing you want to take home from this whole spiel that I'm giving is the idea that you can have a great HACCP program, but it isn't a defense if you cause a foodborne illness outbreak. So what do? You do these things to prevent a foodborne illness outbreak. That's the real thing. I'm a participant in one of the listservs where people send little emails about foodborne illness outbreak. And one of the constant themes I hear is, oh, we have to have a HACCP plan because we don't want to get sued. And that always puzzles me because what people don't seem to realize when they say those kind of messages is that once you get sued, you already have lost the battle because of strict liability and because of constructive knowledge. So what you need to do is rededicate yourself not to bashing lawyers and not to saying, well, we have to do this because our in-house counsel tells us we need a HACCP plan and we need sign-off forms and we need all these other things. You need to do this because you don't want to make people sick. Risk assessment with respect to litigation is buying insurance. That's what you do in case you get sued. But the real cost of litigation are the kind of things that insurance doesn't compensate you for, and that is the damage that goes to your reputation. As I mentioned earlier, in the last year, we filed 3 class action lawsuits on hepatitis. One of the complaints is in there. It's against Carl's Jr. Another one was against McDonald's, and another one was against Subway. In all of those cases, their insurance company will hire them an attorney. They'll pay whatever judgment is assessed to them. Typically, these cases all settle. In my 8 years of foodborne illness litigation, I think 3 cases in which I've been involved have gone to trial. None of them have gone to verdict. So the vast majority of these cases settle. And why do they settle? Because of strict liability and constructive knowledge. Typically, in a foodborne illness lawsuit, the only issue in some cases is whether or not a particular restaurant caused, or manufacturer or whatever, caused the particular outbreak. And in those cases where it is really a close call, where it is a coin flip, my firm doesn't get involved typically. We don't get hired unless the epidemiologists, the health departments have already come to a conclusion. The state health department issues a report and says this is the cause of the outbreak. And then you have a lawsuit. So what I would encourage you to think of today is don't fear me. Don't think you're going to do these HACCP systems because you don't want me filing a complaint against you. Do it because you owe it to your customer and you don't want to get people sick. which I'm sure is the case. Because once someone gets sick, there isn't any defense, and all the HACCP systems in the world isn't going to be a legal defense to you. Thanks.